Welcome to The Explainer, where we dig into the original source material to understand some of the most fascinating stories out there.
Okay, let's just jump right in. We're looking at a pretty wild Supreme Court case from way back in 1893, and it all comes down to this single question. A man is shot and killed. Everyone knows who the shooter is, so how on earth does someone else get convicted for the murder? Let's unpack this.
All right, so let's set the scene. We're in the Cherokee Nation. It's the morning of February 13th, 1892. And this is right after a long night of drinking and dancing that basically went on until sunrise. The party's over, but the trouble is just about to begin.
So after this all-night party, a guy named Andrew Colvard invites two other men, Stand Rowe and John Hicks, to come home with him. But what starts as a friendly offer, well, it goes south fast. They meet up on horseback, and Stand Rowe just pulls out a Winchester rifle and aims it at Colvard. He does this twice, and then he fires. Colvard is killed instantly.
Now, get this. This whole thing didn't happen in a vacuum. There were 4 eyewitnesses watching from a porch about 100 yards away. They saw the whole tense interaction. They saw Rowe aiming the gun. But, and this is absolutely crucial, they also saw and heard what the third man, John Hicks, was doing right in those final moments.
So here's the twist. Stand Rowe, the actual shooter, was killed while he was resisting arrest. That left the authorities with a really interesting question. What about John Hicks? Well, the prosecution decided to put him on trial for murder, even though everybody agreed he never even touched the gun.
The prosecution's entire strategy was built around this one legal idea, aiding and abetting. Their argument was basically, look, Hicks might not have pulled the trigger, but his actions, his words, they encouraged Rowe to do it, and that makes him just as guilty as the shooter.
And this is what it all boiled down to. According to those witnesses, these are the absolutely chilling words that John Hicks yelled to the victim, Andrew Colvard, right before the final shot was fired. For the prosecution, this was the smoking gun. It sounded like a clear command, like undeniable encouragement. But of course, there are two sides to every story. When Hicks got on the stand, he told a completely different one. He said, no, that's not what I meant at all. He claimed he was actually trying to talk Rowe down, that he was terrified Rowe was about to shoot both of them. Those words, he argued, weren't an order, they were a cry of pure desperation.
The jury, they didn't buy it. They found him guilty of murder. But the story doesn't end there. Nope. It goes all the way to the Supreme Court. And the justices, after looking at the case, found 2 massive critical errors in the original trial that changed everything.
So the court honed in on 2 major problems with the trial. The first had to do with intent. What was actually going on in Hicks's mind? And the second was a big problem with credibility. Basically, who the jury was told to believe. Let's dig into both.
Okay, this is the first huge mistake. The judge at the trial told the jury more or less that if Hicks's words had the effect of encouraging the murder, then he was guilty. It didn't matter what Hicks intended them to mean. But the Supreme Court said no, that's not how the law works at all.
And the Supreme Court, through Justice Shiras, basically said, whoa, hold on a second. The prosecution can't just prove his words sounded bad. They had to prove that Hicks actually intended for his words to encourage Rowe to commit murder. The effect isn't enough. The intent is everything.
Now for the second error. This one's a little more subtle, but it's just as big a deal. When the judge was giving instructions to the jury, he described the situation as a conflict between what Hicks said and what was said by, and I quote, the other witnesses who were telling the truth. You see the problem, right? By saying the other witnesses are telling the truth, the judge basically put his thumb on the scale. He signaled to the jury that he, the guy in the robe, had already decided who was credible and who was a liar. The Supreme Court saw this as hugely prejudicial. It completely undermined Hicks's right to have his testimony fairly heard. Now, you might think that's a slam dunk case, but not everyone on the Supreme Court agreed. Justice Brewer wrote a really passionate dissent, basically arguing that the rest of the court was getting way too bogged down in technicalities and that the guilty verdict was the right one. So the dissent, led by Justice Brewer, really pushed back on a couple of things. First, he said Hicks's lawyers didn't object properly during the trial, so it was too late to complain now. But his bigger point was about the word abet itself. He argued that you can't accidentally abet a crime. The intent is bigged right into the definition of the word, so he felt the judge's instructions were fine.
So after all that legal back and forth, what happened? And what's the big takeaway? Why are we still talking about a case from way back in 1893?
Well, first, the result. The conviction was thrown out, totally reversed. Because of those two huge errors by the trial judge, the Supreme Court said John Hicks deserved a brand new trial.
And here's the lasting impact. The big idea this case really hammered home for American law: your mindset, your intent, is just as important as your actions. To be guilty of something like aiding and abetting, it's not enough that your actions had a bad result. The prosecution has to prove you had a guilty mind.
And that second error about the judge's comments, it leaves us with this really critical question that courts still wrestle with today. Just how much influence should a judge have? How far can they go without unfairly swaying the very jury that's supposed to be impartial? It's a question that gets to the very heart of what we mean by a fair trial.